Hi everybody, this is the lecture video for assignment number 33, in which we will be talking about economic substantive due process. So we were talking in our last class discussion in the last video a little bit about the two different types of due process that the court has recognized. And we spent some time in our last class talking about procedural due process. But we also introduced the idea that there is this type of due process referred to as substantive due process. And this is what we will be talking about for the last bit of time we have together this semester. Now, the court has really had two major lines of cases that are forms of substantive due process. The first are cases that recognize economic substantive due process. These are cases that tend to focus on the court's recognition of the liberty right to enter into contracts and to make decisions about your employment or your trade. And the court was deciding these cases during the period that, when we talked about the Commerce Clause, we refer to as the pre-New Deal era, from the late 19th century and into the early 20th century, ending in 1937. And this is the line of cases that we will be talking about today in this lecture and in the next lecture. The other line of cases where the court has decided substantive due process rights involve the concept of the due process protecting the liberty of privacy. So they involve rights that the court has put under the umbrella of being a constitutional right to privacy. So these flow out of initially a recognition of a constitutional or fundamental right in matters of family autonomy, and then they flow into areas of reproductive autonomy. Ultimately, the court decides cases dealing with abortion. There's other cases too under this umbrella of privacy involving things like the right to make your own medical decisions, to refuse medical treatment, to the right to have the right to die, perhaps with the assistance of a physician. So those forms of substantive due process, the privacy interests, will be what we're talking about next week in our last couple of classes. So before we begin talking about economic substantive due process, just a very sort of quick review about what we mean when we talk about substantive due process as compared to procedural due process, which we talked about in our last class, at the risk of sort of boring you to death with making sure we understand this distinction. So procedural due process, as we talked about, refers to the procedures that the government must follow before it can take away our life, liberty, or property under the due process clauses of both the 5th and the 14th Amendment. By comparison, substantive due process refers to the theory that these two clauses, the due process clauses, guarantee that our life, liberty, or property will not be taken away from us without the government following certain procedures, but also that the due process clause protects a substance of these rights. And this can take a couple of different forms. One is that substantive due process requires, as part of this substance inquiry, that the court examine the government's justifications for infringing our rights. So the government doesn't just have to follow certain procedures, it also has to have a sufficient reason before it can deprive us of these rights. Substantive due process also is a reference to the practice of the court of interpreting the due process clause's protections of our liberty as including both rights that are enumerated, that are listed in the Bill of Rights, as well as recognizing that we have constitutionally protected liberties that aren't listed, that are unenumerated rights. And we also talk about substantive due process when we are referring to the practice of the court recognizing rights as liberties under the Due Process Clause, as being, some of them being what we call fundamental rights. And that these fundamental rights, the court then, under substantive due process, puts a greater burden on the government before it will allow them to deprive us of these rights. And with that refresher on what we mean when we talk about substantive due process, let's talk about economic substantive due process. So, as I mentioned, when we were talking about the Commerce Clause, we spent some time referring to what we call the pre-New Deal era, this period in court history in the late 19th century and into the early 20th century. And we talked about what was going on a bit in the country at that time, that we had this dramatic increase in industrialization, and thus we had also a corresponding increase in the government attempting to regulate industry. At the same time this was going on, there was a rise in the popularity of what's referred to as laissez-faire economic theory among scholars and among a number of judges, including a number of justices who were on the Supreme Court. This economic theory purports or believes that the less government interference we have in the economy, the better, that it's better both for the economy and for just the development of our society. So when we talked about the Commerce Clause during this period, we saw that the Supreme Court was invalidating a number of federal laws that were attempting to regulate the economy and regulate matters of employment. And the Supreme Court said Congress couldn't pass these laws because they exceeded Congress's powers under the Commerce Clause. Well, during the same period, from roughly 1887 to 1937, at the same time, the Supreme Court was also striking down laws that were passed by states that were also trying to regulate economic matters or issues related to employment. So they're striking down the federal laws, saying Congress didn't have the power under the Commerce Clause, and then at the same time striking down the same types of laws coming from the states. And they were doing so based on the theory that these laws violated our individual rights under the Due Process Clause. So this whole period in the court's history is often referred to as the Lochner era, named after the case that we are discussing today. And it's an exceedingly important time in the court's history because it was the first time that we had federal courts on a very consistent and regular basis striking down not only federal laws, but also state laws, declaring them to be unconstitutional. During this period of about 40 years, we had the Supreme Court declare more than 200 state laws to be unconstitutional. And there's a number of people who believe that what the Supreme Court has done since the end of the Lochner era is in large part perhaps a reaction to what are the perceived, at least, evils of what the court was doing during the Lochner era. So since 1937, we have a Supreme Court that has basically refused to protect any kind of individual economic liberties as a constitutional right, which, as I said, many people believe is a reaction. Some suggest perhaps an overreaction to the mistakes that the court feels it has learned during the Lochner era. Lochner has also become a powerful tool for the justices to invoke when they want to criticize the other side. We saw Justice Souter do this when we read the Lopez case and his dissent. He cited to Lochner, and he talked about the Supreme Court's disregard for Congress's view in that case that the gun law was indeed a proper law. So criticism of the Lochner era is not necessarily a general rejection of the idea that the Commerce Clause should be interpreted more narrowly than it currently is. And it's also not necessarily a rejection of substantive due process, a rejection of the theory that the court should be recognizing certain liberties as heightened liberties protected under the due process clauses. But it really was the combination of the two of these things going on at the same time, along with perhaps some historical evidence suggesting that the justices actually did personally favor a particular economic theory that has led to this era becoming associated with what is really deemed to be judicial overreach. Former Judge Robert Bork once called Lochner, quote, "the symbol, indeed, the quintessence of judicial usurpation of power." Chief Justice John Roberts, during his confirmation hearings, said, quote, "You go to a case like the Lochner case, you can read that opinion today, and it's quite clear that they're not interpreting the law, they're making the law." So Lochner really symbolizes what I think is the key dilemma that we have been wrestling with in this class. How can we have the Supreme Court and the federal courts in general protect things like the separation of powers or state sovereignty or individuals from government intrusion into their rights and liberties without opening up the door for the justices to become the unelected policy-making branch of our government? And indeed, the Supreme Court and a number of commentators have really struggled for the last 50 or more years trying to develop a model of constitutional interpretation and of judicial review where the court protects things that we think are important, like individual liberties, without incurring these evils of Lochnerism. So let's talk a bit about the case itself. So this is a case from 1905, and it involves a statute that was passed by the state of New York. They enact this law which limits bakers from being able to work more than 10 hours a day or more than 60 hours a week. So the court in Lochner tells us that this law violates the Constitution. And in particular, it tells us that it violates the protections for our liberty in the Due Process Clause of the 14th Amendment. And the liberty that it says is being infringed is what they call the right to purchase and sell labor. That this state law prevented bakers from entering into contracts to work more than 60 hours a week. It also prevented their employers from being able to hire bakers and agree to enter into a contract to pay them to work more than 60 hours a week. So we have this individual liberty of both the bakers and the employers that the court says is being infringed. So this leads us to the first key point that we take from the Lochner case, which is the court told us that the liberty provision of the Due Process Clause, the liberties that are protected by the Due Process Clause, protect substantive rights. And in this case, the court was particularly concerned with the idea that we had a liberty of the freedom to enter into contracts, particularly employment contracts of our choosing. When we talked about the Commerce Clause, or when we've talked about the federal government's powers, we've spent a lot of time talking about how the federal government needs to be able to point to an enumerated power before it can pass any kind of legislation. Whereas the states, we said, retain all other power to legislate. But the Lochner Court doesn't seem to see it quite that way. Instead, they recognize that the states have their police powers, their power to legislate for the protection of public's safety, health, welfare, and morals. But the Lochner says the state needs to be able to point to which of its police powers it is using. So any state powers, they said, that are use of state powers that are in conflict with the individual liberties that are protected by the 14th Amendment would not be upheld as constitutional. The court says, which should sound familiar to us from its logic in the Commerce Clause case, that we need to interpret the state's powers with this narrowing interpretation, because otherwise the states are going to have unbounded, unlimited powers. And so the court needs to, through interpretation, be sure to be able to place some kind of limitations on the kinds of laws that states can pass. And so our second key takeaway from the Lochner case is that the court is telling us during this period that the state can only infringe on liberties. In this case, it is concerned with the freedom of contract, if it is doing so specifically for police purposes, of which the court talks about protection of public safety, health, and morals. And that any interest that is sufficiently going to be sufficiently important only if its goal is going to be to accomplish a particular end. And they say only these police powers are the only sufficient important purposes. So in this case, the court says we need to know what the state's purpose was of setting these maximum hour laws for bakers. Well, the state here would say that our purpose was to protect the health of bakers, that this does fall within our police powers, that the state was concerned about how working conditions in baking were atrocious. Workers regularly logged more than 100 hours in a week. When they did so, they were inhaling all of this flour dust. Their health was suffering. They had runny eyes. They were pale-faced. They were weakened, and the first ones likely to die, they said, if we had some kind of epidemic. And so it seemed, at least the state would say, that our purpose here was to protect our citizens' health. But the court says, no, that's not what we mean when we talk about how states have the power to protect protect public health. When we're talking about that's police power, we mean protection of public health as a whole. And however many hours the bakers work every week doesn't affect the bread that is produced. The bread, they said, clean and wholesome bread, they tell us, doesn't depend on how hard or sick the bakers might be getting. As far as being concerned about the health of the bakers, the court said, well, the bakers can be the ones to protect themselves. They can choose not to enter into employment contracts that have them work too many hours if they think that this is not good for their health, that we don't need the state to come in and protect the bakers that way. They have the autonomy to make these decisions for them. And they are getting concerned about giving the states too much power, or perhaps unlimited even power. The court says that all labor has some kind of health costs, and if we allow the states to regulate any kind of potential health cost in employment, then they would be able to regulate pretty much everything. So this is going to be a question that I have for you all when we meet in our class Zoom session, which is, what do you think about this argument? The argument that the state has an interest in making sure sort of the public's health, that the bread that is being produced is safe, but they don't have a sufficient interest to come in and narrow what the court says is our individual liberty interest to enter into contracts to protect the baker's health. It's the bakers who can choose whether or not they need additional protections. The bakers can decide that they don't want to work more hours than they think is safe, that it shouldn't be the state that's making these kinds of decisions for the bakers. Okay, so we have this question here about whether or not the states might be overstepping their legislative powers, and in doing so, violate the individual liberty of contract. And another question that raises is the question of whose job is it to take a look at the reasoning that the state is giving for why this law is needed and make the determination of whether or not that reason is sufficient for constitutional purposes. And the court here in the Lochner era tells us that it's their job, that it is the role of the court under due process to take the closer look at the state's justification. They say that the court needs to ask, is this a fair, reasonable, and appropriate exercise of the police power of the state, or is it an unreasonable, unnecessary, and arbitrary interference with the right of the individual to his personal liberty, or to enter into those contracts in relation to labor which may seem to him appropriate or necessary for the support of himself and his family. So the court in Lochner emphasizes that it's the job that we need to have the court carefully scrutinize state laws to make sure that their purpose really is about regulating the health of its citizens. And not only that, but they also tell us that the burden that the state has to show that this law is needed is that they can't just show simply that this is a legitimate law, that it is rational that we need a law like this, sort of this lower level of scrutiny that we've seen the court use in other cases like the McCulloch case, but rather the court in Lochner tells us that the state needs to show that it has an important purpose and that this law is necessary or even indispensable in order to achieve that goal. And not only does the court conclude that the state's law here with its maximum hours for Baker's law is not necessary, but the majority here is suspicious that this law really has anything to do with anybody's health, whether the public's or the Bakers. The court instead actually seems to have this actual fear. It's not explicitly stated in our excerpt, but the court's real fear seems to be that the state might be using its power to redistribute wealth from the employer to the employee, that the state just wants to use its power to take from one group economically in order to benefit another. The court says that this law is not, quote, within any fair meaning of the term, a health law. So we have here in these descriptions of what the court is doing in Lochner are concepts of substantive due process. We have the court looking at the protections for liberty in the Due Process Clause of the 14th Amendment and telling us that there are substantive rights that are protected here as one of our liberties. And in this case, the court recognizes that the freedom of contract is one of these liberties that's protected, which is not an enumerated right. It's not a right that we find in the Constitution or in the Bill of Rights. We also see in these other two steps, the court exercising this other concept of substantive due process, that the court is concluding that it's its job to take a look at the justification that is given by the government for infringing on this individual liberty, and it's the job of the court to consider whether or not the justification is sufficient. And indeed, the court is telling us that there can be some kinds of rights that are important enough that we're not going to simply defer to the legislature and just ask if their law was rational, but rather we're going to put a pretty steep burden on them, and give them the burden of showing that their law was actually necessary. After the Lochner decision was decided, we had a really interesting phenomenon that developed. Which is that we began to have attorneys write very long and very detailed briefs that they would present to the court that would at least allege to be presenting scientific and sociological data, trying to prove to the court that there really was a public health and safety need for the law that they were defending. One of these briefs that became quite famous was in the 1908 case, 3 years later after Lochner, called Muller versus Oregon. This involved a maximum hour law for women who worked either in a factory or in a laundry. And there's a brief that's referred to as the Brandeis brief that was a 113-page brief, and that it included all of this so-called scientific data that purported to show that excessive non-domestic work, I always like the non-domestic part, excessive non-domestic work or rigorous academic study could bring about serious harm to female reproductive systems. The brief argued that, quote, the physical well-being of woman becomes an object of public interest and care in order to preserve the strength and vigor of the race. So they're arguing that this is a matter of protection of the public's health, not just any individual woman's health. So the Supreme Court in that case accepted this argument about the need to have maximum hour laws for women. So this one, they said, was a sufficient state police purpose. But during the Lochner era, we had the court using its powers to strike down just an incredible variety of legislation. Minimum wage laws, maximum hour laws, consumer protection regulations, generally any kind of pro-labor, pro-union laws. And just as a reminder, at the same time they were doing this, saying these violated due process, if the federal government was passing these same types of laws, they were saying that they were unconstitutional because they intruded too much into the state's sovereignty. So we had a period in this country where the entity, it seemed, that had the most power over our country's economic policies was not our democratically enacted political branches, but rather the Supreme Court justices themselves. Justice Holmes's dissent in the Lochner case is very famous. In his dissent, Justice Holmes accuses the majority of basing their opinion in the case on an economic theory that a large portion of the country did not necessarily believe. And his most famous line in the decision is he says, the 14th Amendment does not enact Mr. Herbert Spencer's social statics. Herbert Spencer, for those of you who may not know, was a prominent social Darwinist. He's the one who is known for coining the phrase survival of the fittest. And so by telling us that the 14th Amendment does not enact Mr. Herbert Spencer's social statics, Holmes is accusing the court of substituting its own economic judgment for that of the majority. This is a particularly strong statement to come from Justice Holmes because he was publicly known for being a supporter or a follower of Spencer's libertarian views. But nonetheless, he is telling the majority here in Lochner that they are not simply just being neutral in their interpretation of the Constitution, but he says they are being influenced, whether they realize it or not, by their own personal biases. And in fact, he's saying that judges are often influenced by their own personal beliefs and values. And there we have a picture of Mr. Herbert Spencer himself. So Justice Holmes's dissent raises the question of, if the justices aren't being neutral, or perhaps even can't be personally neutral when they're interpreting these economic policies, then whose opinions should they be trying to implement as they interpret the Constitution? And what Justice Holmes is really representing here in this dissent is the rise that was beginning in the early 20th century of what is referred to as legal realism. Before this period, it was widely believed, and the justices themselves certainly believed, that there was simply a natural order of things. Courts could be neutral if what they did was simply return things to their natural order. But the legal realists came along and started to say that there is no such thing as this idea of natural law or this natural order of legal rights, but rather law can be just as much the result of human choices and preferences as political policy can be. So for example, our tort law can be a series of human choices that tends to perhaps favor employers over workers. Or our property law is the result of human choice that favors landlords over tenants. And the legal realists should argue that understanding this and accepting this role of humans in making law and this lack of there being natural law that sort of floats above us for the court to simply reach out and recognize, means that the courts really should be deferring to legislatures as much as possible. That legislatures are the better group to be making these human choices. So Justice Holmes was a prominent legal realist. And he has a couple of kind of famous quotes where we see his views on legal realism. One of them is where he wrote that property, a creation of law, does not arise from value, although exchangeable, a matter of fact. I'll admit I've always found this Holmes quote a little bit frustrating because it always seems like it is close to, but not quite, a haiku, which it seems always a little frustrating. And I think it's also a touch confusing what exactly he is telling us. But he is saying to us in this quote that property is a product of our legal rules. It's not something that just arises naturally. And the economic value of property is not something that like predates law, but rather it was something that was created by law. And it's based on judges' personal views about society and even how they see reality around them. And all of this, he tells us, is simply just a matter of fact. So by the same token, in the Lochner case, he is telling the majority by telling us that the 14th Amendment does not enact Mr. Herbert Spencer's social statics, that laissez-faire economics, this absence of government regulation in the markets, is also not something that is sort of the neutral, natural state of things, but also the result of human choices or legal choices. In another quote from a letter that Justice Holmes wrote that perhaps expresses his approach to legal realism a little more clearly, he once wrote that if my fellow citizens want to go to hell, I will help them. It's my job. He did not think that it was the job of the Supreme Court to be second-guessing the results of the political process or the wisdom of legislation. And that brings us to the end of our discussion of the Lochner case and the Lochner era. In our next video, we will talk about what happens next when we have the rather quick demise of the Lochner era.